Chairman of the Bar Council of Andhra Pradesh, Vice Chairman, the Coordinator, the other dignitaries on the dais and off the dais, friends, ladies and gentlemen, today's session as we have, in which I'm asked to address, is on the right to property vis-a-vis the constitutional aspects. Now, Mr. Ganta Ramarao, who had spoken to me, had informed me that most of the participants here are from the trial courts. And then I've asked him as to what is the relevance, because the constitutional aspects of the right to property may not be of a regular relevance for you in the practice. But nevertheless, he said that it is good for the trial court lawyers also to know the constitutional rights which are guaranteed with respect to this property. And that would also help you all. Now, this right to property on the constitutional side is a very, very vast subject. Maybe that the kind of amendments which have been brought into force, amendment of the Constitution itself, and the 9th schedule, so many, almost about 250 statutes have been placed into the 9th schedule. What is the significance? I will broadly touch upon without going into the very intricate aspects of it, because they are very, very highly technical and it requires a very long discourse to explain as to the purpose of each of the amendments to the Constitution and so on and so forth. Now, dealing with the concept of property, the right to property is a very, very cherished right. One of the jurists, Montesquieu, he said that the right to property is so dear that a person may forget the murderer of his father, but a person would never forget in his life who has taken away or snatched away his property. The right to property is so much cherished. That property is the one which gives you a sense of security. Property is the one that indicates wealth. Property is the one that indicates your social status, and so on and so forth. Property is also, apart from the immovable and the tangible property, we also have certain intangible properties like the intellectual property and other things, which I'm sure the other speakers are going to touch upon. Now, the property as such and the ability to hold property originally was only by the muscle, by the strength of the person, because then there were no conferment of title or right to property or anything of that nature. So as the concept of property has evolved from time to time, the states, the administrations, the statutes, they have become very important. Some of the countries, right to property is a fundamental right. In some of the countries, right to property is not a fundamental right, but it's a statutory right. Some of the socialist countries, in those countries, the right to property, there is in fact no such right at all. Or it is said that it is the most indefensible right, which means that no law protects you from the state taking away your property, because there is no ownership of a property, of a private ownership of property as such. That was the situation. That is the present situation even in all the socialist countries. Bill of Rights, America recognizes the right to property as a fundamental right. Now, we deal with this concept today with regard to two periods. One is the pre-independence period and the other is the post-independence period. Right to property in the pre-independence era, the British era, was under the Government of India Act 1935. Section 707 of the Government of India Act had incorporated the provisions with regard to not the right to property, but the manner in which a citizen's property can be taken away. Now, apart from the private rights with regard to property that the trial court advocates regularly deal with under the Transfer of Property Act, and of course under the various agricultural land transfers by way of registration, etc., the state we are concerned with, because the right to property vis-a-vis the Constitution, we will only be discussing as with regard to the power of the state to take away your property, and in what manner can the state exercise its power to take away your property. So the property can be taken by the state only for two reasons. One is for public utility, and the other is that where there is necessity for any other purpose, the state will have to justify that the property can be taken only in accordance with the procedure established by law. Originally, under the Indian Constitution, Article 19(1)(f), Article 19, Subarticle 1, Clause F, which is in the Fundamental Rights chapter, dealt with the right to property. It conferred a fundamental right. Now, before we deal with these, I will just broadly touch upon as to what is the Constitution and what is the significance of the fundamental right, and also as to what is the significance of the directive principles of state policy. As my predecessor, Justice L. Nageshwara Garu, was just mentioning about the Suprema Lex, which is the supreme law of the land, that is the Constitution. As we have enacted it, in Chapter 3 is the core of the Constitution, which deals with fundamental rights. The importance of this is that you will find it under Article 13, Clause 2, which says that state shall not take away or abridge the fundamental rights what are enshrined in Chapter 3. These fundamental rights, starting from Article 12, way up to Article 35, they all are under Chapter 3 of the Constitution, and they deal with the fundamental rights. They confer or they guarantee to the citizens of this country the fundamental rights. Now, when once something is placed in Chapter 3, that is the Fundamental Rights chapter, the state cannot in fact abridge any of these fundamental rights, not even by a procedure established by law. That is the reason why I am saying that Article 13 is the core of the very Constitution itself, which protects the fundamental rights and protects the citizens from being deprived of their fundamental rights only through this Article 13, Clause 2. This is very, very essential. This particular article, by which it says that the state cannot make a law that takes away or abridges a fundamental rights, has become a subject matter of discussion and debate for a long time, ever since the Constitution has been enacted. Now, as you all know, that the preamble of the Constitution also deals with the socialistic economy that what is contemplated, and the social rights of individuals. Then we have Chapter 4 that deals with the directive principles of state policy. These are also important, but the difference between Chapter 3 and Chapter 4, the students studying constitutional law must be able to say what is the difference.
Chapter 3 speaks about fundamental rights, sir. Chapter 4 about DPS.
That's okay. But again, the Parliament, whether it can amend the fundamental right in such a manner that this fundamental right cannot be challenged in any court of law if a statute is placed in the Schedule 9 of the Constitution. So this is another very interesting brainstorming challenge which has been brought about. Now the Supreme Court has considered these aspects and had felt that the fundamental rights are definitely fundamental. Article 13(2) is the core which protects the violation of a fundamental right of a citizen, but the common good is superior to the individual right of a person. So where a particular statute is intended to bring in a social change by creating for a common purpose, for a common good, then these fundamental rights must give way to the common good. So that is the philosophy which has been advocated by the Supreme Court. And also, on a technical ground, the Supreme Court had said that Article 13(2) only deals with, it states that the state shall not make a law. So the law means that it is with reference to the legislation made by the Parliament, and it is not the constituent power under which the Parliament has exercised its right, and therefore these laws are constitutionally valid. It's a bit technical and complicated, but I don't know if I've made my point clear to you. The difference, so the explanation given by the Supreme Court in upholding this particular provision is by saying that the law, the word law which is used in Article 13, Clause 2, refers only to a legislation. Legislation means, see, the Constitution is something different from a legislation. The source of legislation is the Constitution, but the law which is enacted by the Parliament is merely a legislation, and therefore this legislation is not covered by, is not hit directly by the fundamental rights. So in this manner, the Supreme Court had upheld the First Amendment to the Constitution. Then thereafter there is a few amendments, and continuously the states have been enacting various agricultural reforms in the form of, even we also in Andhra Pradesh, we have agricultural reforms. Then we have the Urban Land Ceiling Act, which also was brought into effect. Now, all these were protected only because they have been placed in the 9th schedule of the Constitution of India. Then we have thereafter, in Sajjan Singh again, the same principle was raised. Then there was a 7th amendment which is made to the Constitution for placing certain acts in the 9th schedule of the Constitution. And that also came to be challenged. Following Shankari Prasad, in Sajjan Singh also Supreme Court has ruled that it is possible. And fundamental rights can be abridged only for a common good. Then in Golaknath, 17th Amendment to the Constitution came to be challenged, again placing another land reform statute in the 9th schedule. In Golaknath, the court found that this is not possible. So I think 6 judges majority have ruled that what is said in Shankari Prasad and Sajjan Singh are bad in law, and the state has no power and no right to amend the Constitution in such a manner that it can deprive the fundamental right of a citizen. Now, this happened in the year 1963. Now look at this situation. From 1951 up to 63, the position was that the states could enact statutes and place them in the 9th schedule so as to keep them away from the challenge by the citizens with regard to violation of a fundamental right. Now, a lot of people have already been deprived of their land by virtue of the land ceiling enactments, where for each unit a particular ceiling of land has been fixed, and one person, a unit of a family can only hold a particular extent of land. So over and above that, the land would vest with the government. By then, a lot of people have already lost their lands. Now, all of a sudden, in Golaknath's case, the Supreme Court then says that this law is bad. Then what is to happen? Should the land be given back? So the Supreme Court had then said that we are overruling the previous judgments prospectively. That means only from today, the effect will be there, the protection of a fundamental right will be there, but for the things which have happened in the past, this law, what we are declaring today, is not applicable. That is what is called as the prospective overruling. What is important for us today is only with regard to the situation in which the property law has undergone continuous change. Maximum litigation in this country has happened only with regard to property law. It is a cherished one. Nobody would like to lose right over the property. Then came the Keshwananda's case, which is again related to the property, where the theory of basic structure was propounded. Then that is again a different chapter which will take a lot of time to discuss all the intricacies, but what is necessary in this case is simply to say that there are certain basic structures in the Constitution and you cannot violate it, but at the same time, what has been held in Golaknath and so on and so forth came to stay. So then what happened is, by virtue of the 44th Amendment to the Constitution, Article 19(1)(f), which has been there all along, but has been diluted to a major extent by virtue of this First Amendment, Fourth Amendment, 17th Amendment, then partly 24th and 25th Amendments also. The government has realized that so long as this fundamental right remains, then we cannot freely go ahead with these agricultural reforms, and had brought in, by virtue of the 44th Amendment, it had repealed 19(1)(f), Article 19(1)(f). It has repealed and has placed this article from removed it from the fundamental rights chapter and has placed it under Article 300A. Article 300A of the Constitution says that a procedure, that the state shall not deprive a person of his property except by a procedure established by law. So today the situation is that the law as what it exists, and we have the land acquisition statutes also, that only in public interest and by exercising 19(5), subclause 5, by virtue of reasonable restriction, somebody can be deprived of his right to property only for public purpose. We had the Land Acquisition Act of the 19th century, and that has been repealed, and a new enactment has been brought in the year 2013. So now the compensation, also there's been a lot of litigation as to what is the compensation, what is a just compensation. Today the law on compensation is that the real value of the land should be paid to the person who is deprived of his land. So that is the way in which this law has undergone various constitutional changes. Now, if you have any doubts or anything, then you can, because these are issues which will take a very long time to discuss each and every amendment, which is not possible in this today's discussion. But if you have any other doubts on, that's what I've also said. But what is the difference between these two? I'll just.
Fundamental rights are enforceable.
Exactly. Yes.
In the court. If
Yes.
it is violated, you can approach the court whether directive principles of state policy were implemented by the government during their government.
Yes. Yes.
If it is violated, you don't have any right to.
That's right. Very good. So therefore, as a young friend has clarified, that these fundamental rights are justiciable. Directive principles are non-justiciable. Now, what is the meaning of justiciable and what is the effect of something being non-justiciable? Justiciable means if there is a breach to your right with regard to any of the provisions in Chapter 3, you can bring an action in the court of law. You can challenge that breach of a fundamental right before the court, before the constitutional court, that is the High Court and the Supreme Court. Whereas the directive principles of state policy are only merely directive in nature, but nevertheless very important. They are very important, but they are non-justiciable. Now, how and in what way are the directive principles, as what I was just mentioning, which are there in Part 4 of the Constitution, so important? Article 39 specifically says that the state shall endeavor to reduce the disparities and also in striving towards social justice, and also to see to it that the state's natural resources and the other resources are not concentrated only in a few hands. Today, while we are dealing with the right to property, it becomes very, very essential to understand as to the transformation of the constitutional provisions with dealing with the right to property, why and how they have taken place. So, at the time when the Constitution has been adopted by us, the government has rather perceived that 80%, because as I was just mentioning, that Article 39, the state shall endeavor. The state means the government of, be the central government as well as the state governments, shall endeavor to see to it that the natural resources of this nation are not concentrated only in a few hands. That means what? It means that a few people in the country should not be allowed to exploit these natural resources, while the natural resources are meant for the common good, that is to be used for the whole society, the whole nation, people of the whole nation. So in order to give effect to this, the government has seen that 80% of the natural resources, because India is an agrarian country and our economy is an agrarian economy. Our economy depends on agriculture. And the country our rulers have realized that 80% of the agricultural land which is available is only concentrated only in about 15% of the people. Badly, perhaps because of the British, the administration which concentrated in encouraging the Jamindari system, as they are called as Bhumihars in the north, where the British itself has actually encouraged only few people to hold the land so that these people will be responsible in paying the revenues to British on the land that is held by them, and allowed this ownership of land to remain only in about 14% or 15% of the people of this country, controlling 80% of the land. then what can you do? You have fundamental right on one hand, which says that the state cannot make a law which takes away a fundamental right. As on the date that we got the independence, 80% of the people, 15% of the people who are already owning and holding and controlling 80% of the land. Now, how do you reconcile these two? On one hand, you have the fundamental right not to make a law to take away. Now, a right has already set in the hands of a few people, right of ownership of land. So if you have to take it out, it is this 19(1)(f) which is coming in the way. Article 19, subarticle 1, clause F, which is coming in the way in making any law to take this land from the people who've been holding this land and to distribute it to the landless people. That is what has been perceived, the first constitutional amendment has been made by the Constituent Assembly itself. Now, during the Constituent Assembly debates, now there's a difference between the Parliament of India and the Constituent Assembly. This is also one aspect which, of course, most relevant for the High Court advocates, but definitely even the trial court advocates also should know, that the Constituent Assembly has been formed only for a purpose of enacting the Constitution. They are not elected representatives. They have just been appointed immediately after the independence, and their purpose would be served, and it becomes functus officio the moment the Constitution is enacted and adopted. Now, thereafter, it is the election which has to take place. The Parliament has to then would become the lawmaker for the country. Then, the Constitution also provides a provision which empowers the Parliament to amend the Constitution, that is Article 368. Article 254 is also relevant in the sense that in order to make any amendment to the Constitution, there is a power in the Parliament even to amend any provision of the Constitution. Now, even by this, by the operation of Article 13(2), it can be understood that you can amend anything, but you cannot amend the fundamental right. Whereas fundamental right, the right to hold property is a fundamental right. So, the very Constituent Assembly which has enacted and given the Constitution to the country, sat and again had brought in the first amendment to the Constitution. And by the first amendment, Article 31, Article 31A and Article 31B have been inserted into the Constitution, which is also a part of the fundamental right. Now, what is Article 31A and Article 31B? 31A says that anything which relates to the property, if any law reforms are brought in, agricultural or agrarian reforms, they cannot be challenged in the court of law on the basis of violation of a fundamental right. Article 31, capital A. Article 31, capital B says, Article 31, capital B has created Schedule 9 of the Constitution. And it says that any statute which is placed in Schedule 9 of the Constitution, again, cannot be challenged in a court of law for violation of a fundamental right. So by this, the Parliament thought that it can now very freely introduce land reforms and so on and so forth. Then the first challenge came, challenging the constitutional amendment, first constitutional amendment, in Shankari Prasad's case. Very interestingly, the issue that was raised is that this first amendment, which is brought by the Constituent Assembly, The challenge is the Constituent Assembly does not have the power to amend the Constitution. Because it is a Constituent Assembly which has enacted the Constitution and given it to the people of this country, exercising its constituent power. Thereafter, it is only the Parliament which can. Fundamental rights or the right to hold property vis-à-vis the Constitution.